Thank you very much for my introduction. As mentioned, I'm coming from Slovenia, University of Maribor, and I would like first to thank organizers. Thank you very much for all your support during the whole year, and I'm especially proud to be member of this project and especially glad to be here. That is the second time in this year that circumstances make possible that we met. Of course, last year was a little bit problematic. So I will address in my presentation parental responsibility from autonomy to deprivation. And we could speak about parental responsibility. We heard today so many different points, views, so we can just speak about parental responsibility all day long, and I will just give special emphasis on the deprivation of parental care. Okay, perfect. It was interesting that two lecturers in the prior session started also with the Constitution. It is almost the same slide, but of course in Slovenian Constitution from 1991, there's Article 54, which provides that parents have the right and duty to maintain, educate, and raise their children. These rights and duty may be revoked and restricted only for such reasons as are provided by the law in order to protect child's interests. Of course, that was also almost every lecturer today mentioned the definition of parental responsibility, especially my colleague Lila made great lecture. And of course also in Slovenian Family Code, which is new one, it was adopted in 2017, defined parental responsibility as the entirety of obligation and rights of parents to create, in accordance with their capacities, conditions for the comprehensive development of the child, and obligations and rights of parents concerning care for the child's life, health, upbringing, care and treatment, supervision of the child, and providing for the child's education, as well as the obligations and rights of parents concerning representation and maintenance of the child and managing the child's property. You see, almost all definitions have the same content. Of course, parental responsibility also in Slovenia is built on several principles. I won't introduce each one because they are similar in every regulation. That is the principle of best interest of the child, autonomy, primacy, equality, consensuality, least restrictive measure, graduality, proportionality, and protection of family life. But these principles will be introduced through my lecture shortly in relation to the deprivation. The court must follow the principle of proportionality as the exercise of parental responsibility and obligations and rights arising from it primarily belongs to the parents, from who exercise them in accordance with the principle of autonomy. Parents, therefore, have priority over all others in the exercise of parental responsibility. The basic of premise is that parents act in the best interest of the child. Slovenian courts have a wide discretion in defining the content, what is the best interest of the child, because we could not write in the forward what is the best interest, but the court has in every single case to find the content of the legal standard, and in the practice, Slovenian case law developed number of circumstances which court can help in every single case to find out the answer, what is in the concrete case the best interest of the child. As I already mentioned, Slovenia has new family code, which is applicable since April 2019, and before we had the Marriage and Family Relations Act, which was adopted already in '76 in Yugoslavia. Slovenia was part of Yugoslavia, and we had these legal acts for more than 40 years. It was under some changes, and one of the changes also in 2011 makes possible that the court could use the joint custody, but only in the case when there was no doubt it was in the best interest of the child. But the new family code promotes joint custody, so that is the starting point. Parental responsibility pertains to both parents and is exercised by common agreement. Especially that is important after the divorce, when the parents are not living anymore together, by both parents and in the best interest of the child. If the parents do not live together and the child does not live in the custody of both parents, the parent with whom the child lives in custody decides on the issues pertaining to the child's everyday life and on the child's permanent residence, while both parents decide on the issues that are critical for the child's development by common accord in the best interest of the child. Parents have priority over any other person concerning the right and obligation to protect the child's interest. So we know all that the family life is protected, but on the other side, the state should interfere only if the parents fail to exercise these rights and obligations or exercise them contrary to the child's best interest. In Slovenia, we have some protective measures which should protect the child. And some people are thinking if these measures are used that the court wanted to punish the parents. No, we should all know that these protective measures are for the protection of the child. When deciding on a measure, the court has to follow two restrictions. If the adopted measure is able to provide adequate protection of the child's best interest, such measure should be the least restrictive for the parents. So we know that in the past, children have been taken away from the family for very small reasons. As, for example, today it should not happen. In the exercise of parental responsibility. And if the adopted measure is able to provide adequate protection of the child's best interest, such measure should not seek to take the child away from the family. So we are coming to the withdrawal of parental responsibility. Parental withdrawal of the parental responsibility is most restrictive measure, and it should be used at the end when there is no other measure which could sufficiently protect the child's best interests. And the court may withdraw parental responsibility from one or, of course, from both parents if the child is endangered. For the second, where there are circumstances of the case indicate that there is a little likelihood that they will be able to resume custody of the child, in particular if they have severely violated their obligations or abused their rights related to parental responsibility, or if they abandoned the child or their conduct has manifestly shown that they will not assume custody. But that means that the court in every single case has to find the answer when the child is at risk, endangered. And of course, to answer this question, it is not relevant whether the child endangerment is based on the parent's wrongful conduct, it could be active or passive, such of, for example, as domestic violence, or even non-faultful conduct, such as the onset of the illness. For example, if the parent was involved in the car accident and the parent is in coma for several months, of course, if there is no other parent, someone has to take care about this child. So in this case also, there is no faultful conduct, the parental responsibility will be taken away. There should be no collective withdrawal of parental responsibility. That means if there are more children, for each individual child will be, the court have to find out if there are reasons to take the parental responsibility away from the parent, for each single parent and each single child. In Slovenia, proposal for a withdrawal of parental responsibility may be submitted to the court. The jurisdiction is given to the non-contentious procedure, and the proposal could be submitted by the parent. That is in the case when one parent is filing the proposal against another parent, and this parent must have also parental responsibility. If this parent is also without parental responsibility, he or she could not submit the proposal. A social work center and the child, but the child must be older than 15 years. In this case, there should be the child older than 15 years, and the child must be capable to understand the meaning and implications of the proposal. In this case, when the child is 15 and capable, the child will gain the procedural capacity, which is normally gained at the age of 18 years. But if the proposal is submitted by a person who is not entitled, the court will dismiss this proposal, but the court has to prove, despite that the court will dismiss, and if the court will find out that there are given grounds for the withdrawal of parental care, the proposal will be dismissed, but on the other side, the court will start the proceedings of its own motion. Of course, in every case when the child is involved in the procedure, the court has to search for the opinion of the Center for Social Works. Namely, this opinion will include an assessment of the personal characteristics of the parents' attitude towards the children, an assessment of the parents' educational and moral qualities, an assessment of family, financial, and housing condition. As already mentioned before, we know that have been some cases of the European Court for Human Rights where the deprivation of parental responsibility was based on the pure bad financial situation and housing conditions, and we know that the state should offer such families every possible support and help to keep the child in the family. Then the child needs and other circumstances which may be relevant for the assessment of the best interest of the child. Consequences, of course, the parent will no longer be the legal representative. That means that the child must be put under the guardianship, and the guardian for minors must be appointed. That the child won't live anymore with the parent. It could be already before, when there have been risks, the child could be taken away from the family and already before put under the foster care, or the child, if there are no possibility for parent to take care after for the child could be also given for free for adoption, or even for children who are a little bit older, for example, 15 and more, they're put in the institutional care. Of course, the withdrawal of parental responsibility does not necessarily result in the restriction or withdrawal of the parent's rights to contact. That is especially important in the cases where there is possibility that the child will be returned to the parents, and also does not revoke the parent's maintenance obligation. The measure is not limited in its duration, because, for example, institutional care measure that is limited by 3 years, and parental withdrawal is not limited. But however, it may be reinstated if the reasons for which it had been withdrawn cease to exist, but only if the child has not been adopted. The court will renew the parental responsibility if the reasons for a withdrawal no longer exist and if it is in the child's interest. And for the conclusions, I have some cases from the Slovenian courts. In this case, the court was trying to define what is endangerment. Namely, in this case, the father killed a mother, and the court wrote for offenses other than directly directed against the child, such as the murder of the other parent. there is in principle no reason to interfere with the parental responsibility because the child was not endangered, because parent was very good toward the child, but it was a murder of the mother. But on the other side, the court also stated this parent will be sent to the prison for years, and that is the in this relation, the endangerment may arise if the parent will be absent for many years. Then we have another case, that was the father has no contact with his son for 8 years, that is quite long period, and that time the mother was taking care for the child, and the mother submitted the proposal that the father should be deprived of parental responsibility, and the court stated that therefore in the circumstances established, the deprivation of parental responsibility cannot even affect the father's interest in the relation to his minor son, because there was no contact, no relation between father and the son. As a result of the father's abandonment of obligation of care for the child, the mother take care for the son, but there was no endangerment. But if you remember, we have two other grounds on which the deprivation could be based. Namely, that is, the father has abandoned his child, and he has manifestly shown by his conduct that he will not take care for the child. So he was not present 8 years, that's quite a long period if you're not taking care for your child. Child abandonment will occur when a parent breaks the special and physical link with the child, leaving the child without any protection, care, supervision, thus putting his or her best interest at risk. In such case, it is imperative that a measure of withdrawal of parental responsibility will be imposed, since the parent's conduct clearly demonstrates that he or she is unwilling to take care for a child and that he or she has ceased to fulfill his or her parental responsibility. The withdrawal of parental responsibility will ensure protection and security by other measures. In this case, for example, it is possible to adopt the child or to give the child to the foster care. And there's a quite long case, but very shortly explained. There's also the father who was not living with the child. Mother was living with a new partner, and this new partner made perfect stepfather for the child. He was taking care about the child, and they got an idea: if the father, biological father, would be deprived of parental responsibility, child would be eligible for adoption by this stepfather. So that was intention. But in this case, the court said that it's true that the child has very good situation in the family, that it's true that the child is not wishing to make the contact with the father, but on the other side, there's still open possibility that the father was in prison, of course, when the father will come out of the prison, the father will want to contact the child, and the father could take care about the child. So at the moment, the court said that his father is not able to take care about the child, but in near future, the father could be responsible for the child. And here are some statistics. So you can see that there are not many cases in Slovenia. We have about from 20 to 22 children born yearly. So you can see that there are not so many cases. That is good, of course, if we don't have so many cases. But I was very impressed because if you can see from 2021 to 22, there's a quite increasing of the cases. But I don't have the answer. Maybe... Yes, but it's doubled. It doubled. We have all been worried that when the COVID was present, that the courts didn't have insights in the family. But in that case, that is not true. So you can see that the deprivation doubled. Maybe I will find the reasons, and the next meeting I will give you offer the reasons. And also, for the end, you can see, because we already spoke today, who is mostly deprived, father or mother, and that is also interesting that 2021, in most cases, both parents have been deprived of parental care. So I will search for the reasons and give you the answers next time. Thank you.